A mother from Pretoria has been sentenced to 12 months in jail for refusing to give her former partner access to their child. The High Court in Pretoria found that the woman was in contempt of 2 court orders made by the same court in 2021 and 2022. The judge presiding over this case found that the mother has deliberately disobeyed the court from the beginning of this matter in August 2021. Let's unpack this case further with the managing director of Mashitisho Attorneys Incorporated, with Kholofelo Mashitisho, who joins us now via our video link. And it's lovely to see you, Kholofelo. Thanks very much indeed for making time. You know, this is being described by some as a clear warning to vindictive mothers. But before we get into the legalese, take us through what happened.
Sure. So, and you are right, it is a very stern warning towards mothers. So I'm going to be very practical with this matter because I think the people who are listening this morning deserve practicality of how this matter or how the court dealt with this matter. So in this case, the foundation of this specific application was the Rule 43. Rule 43 is an interim order provided to either, male or female who are going through So an interim order is saying to the court after the divorce for whatever reason. So I'm going to divide the 2 judgments that you mentioned in 2. So the Rule 43 that was granted in 2021 was, we'll call it the Foster judgment because it was granted by Judge A.J. Foster. So in this order, which is the Rule 43 interim order, the applicant in this matter, which is the father, said to the judge, I want as a father, I want access.
Let me apologize for interrupting you, Kholofelo. We're actually struggling to hear you. Our connection isn't that great, and it sounds like we need to hold on to the details. So what we're going to do is try to re-establish that connection and get you a sense of, get our viewers a sense of how we actually arrived at what is really a precedent-setting outcome when it comes to issues to do with custody for the child and the likes. And, as I mentioned at the beginning of our discussion, at least some activists in the space say it's a clear warning for vindictive mothers who are sometimes very deliberate in their attempts to stop fathers from seeing their children. My understanding is that, in fact, this father was also ordered to pay for maintenance amounting to about 15,000 rand a month. He actually adhered to that order, but despite that, was actually barred from going ahead and seeing their child. What is also worth noting is that, in many instances, these cases take a considerable amount of time before reaching finality. And what comes with that is an incredible cost associated with it. And I have no doubt that was certainly top of mind for the judge who also had to deliberate over this issue. Kholofelo Mashitisho once again is joining us this time via our telephone line. And apologies for that, Kholofelo. We were really struggling to hear you. You were still breaking down the 2 cases for us before we unpack how the court came to its finding.
Yes, so I'll repeat basically just in summary. The court in the first matter, the Rule 43, as I said earlier, a Rule 43 is an interim order which is provided while a divorce is ongoing. In this Rule 43, the applicant, which is the father in this matter, wanted his rights protected. He wanted to see the child. He wanted to have access to his child in contact, and this was granted. Alongside that, it was also quite important and mentioned in the current judgment, is he was also ordered to pay 15,000 maintenance towards the child, which obviously we know it's a right. It's a parental right. It's a responsibility. It's an obligation that a parent has to do, which he fulfilled. So then now we look at the second order, which was provided, which was granted. In 2022, the same applicant, the same father went back to the court and said, court, help me, because, the respondent is not complying with the order that you gave in 2021. The order that says I need to, I have access to the minor child and contact. Since the order, it's specified in the judgment that, he hasn't seen the child in 3 years, and this, this is, and then the court said to the applicants in that case, and we'll call them a super order because it was granted by Judge Masupa. This application, Masupa then declared that you are in contempt to the mother.
Right.
Okay? He specifically said, you are in contempt and I'm ordering an imprisonment of 30 days. So I think this is important to note because not only was the imprisonment ordered before but now it's been ordered again, but longer. So I think it takes cognizance or even appreciation that the court does acknowledge contempt of court orders when it comes to access with regards to children. So, the current application now that was granted by Judge P.D. Pasani, which is the current one we're discussing now, in this judgment, the court said, you remain disobedient to two orders. And it again places the court in a position where you're making the court impotent. You're saying, you're looking at judicial orders as a mere mockery of a paper, So the court made very, very strong, emotional, very, very, very strong words towards this woman in the judgment. And said, wow. What is the point of a court order if you can just disobey it?
Yeah, absolutely.
Because at the same time, it then places the court order and, as a paper of value, just a piece of paper you can just throw away and continue with your life. And, constitutionally, that is not how the, court orders need to be, implemented. The case in the judgment that the court, they quoted, it's called Eek versus Passons. And in this matter, the court highlights the duty to observe court orders. And it highlights that this is a constitutional imperative. And disobedience towards court orders or decisions made by courts renders or risks rendering our courts impotent and judicial authority a mere mockery. It then continues to say that the effectiveness of court orders and decisions is substantially determined by the assurance that they're enforced.
Right. So, Kholofelo, if I can come in there, I hear you, and it's such an important message to be sent out, right? What I find interesting, though, is that this respondent, the mother, was actually found to be in breach of this court order and not necessarily being guilty of denying the father access to the child. And maybe I'm splitting hairs here because, you are,
because contempt of court in this instance, the order said the child is allowed to see the father. The fact that she is in contempt, the court is saying you're not allowing that, and it's clear in the applicant's papers. The court does put reference to the fact that they have continuously contacted the attorneys of the mother.
So let me ask the question this way, Kholofelo. I hear you on that. If there was no court order, would this woman be in violation of any law, even if she continued denying the child access to her father?
Well, yes. According to the Children's Act, correct, yes. She'll be in violation of the Children's Act. It's specifically the fact that, the parental rights and responsibilities, children are allowed, parents have, equal rights and responsibilities, child access, should be allowed to the father, or if the father was, the primary residence, the mother should be around access. So yes, if there was no court order, the mother would have still been violating not only the Children's Act, but also the Constitution itself.
Right, sure. The judgment also took some time to comment on the advice or lack thereof that this mother was receiving, given now the high cost she has to pay. And I wonder to what extent anything else could be said about that, the kind of legal advice she was receiving as she continued ignoring some of these court orders.
Look, I'm not one to badmouth my colleagues. Really, I think I don't know what exactly happened in that what mandate that the court, or let me just say in this case, the attorney was given. But yes, she was represented, letters were sent, and the court is very, he puts in paragraph 34 to 37, a very displeasure with regards to how this attorney dealt with the matter. He specifically says that, as attorneys, we are not only have a duty to the client, but we also have a duty to the legal system and the court. So it was either she was ill-advised or not advised at all, or her attorney was just, making common calls that it's fine. You are unlawful conduct, and just disregarded it. So I think, not in this case, the court made an emphasis that it is an ethical duty for the attorney to advise the client accordingly and make sure that they obey the court orders, which are, whether the client agrees or not, the client must obey the court order. And obviously, if she wasn't happy with the court order, there were different reliefs that she could have sought, and she didn't. So now the court goes back to say, this contempt of court, because when you look at contempt of court as a whole, there's two requirements you have to meet. It's the fact that there was a modified disobeyance of the order, right? And secondly, you look at the willful conduct. Was the disobeyance that she committed willful? And in this case, it was.
Sure. You know, the irony is that you've mentioned to us that the Children's Act makes provision for children to have access to both parents at any given time, at least if the parents are available to them. With this judgment now, ironically, this child, at least for 12 months, won't have access to both children. It's a difficult thing to negotiate for the court, isn't it?
I think, yes, it is, because, I mean, I don't know what the result is. I don't know if there was an application to try and think this order. We don't know what's happening, but I mean, the order here, the mother will be in prison. The father is granted access, not access, but primary residency. And I mean, if you look at paragraph 6 of the order, the sheriff, if necessary, must be the one to accompany the child to, the father, which is the applicant. It is unfortunate that, the mother will be in prison, but I mean, I'm sure, there is some sort of arrangement that the child will be able to still see the mother should she, be in prison.
Wow.
So yes, it's both ways, honestly.
Absolutely, yeah. And as the saying goes, those with ears, may they listen. Kholofelo Mashitisho, thanks very much indeed for speaking to us. Really do appreciate your time. Kholofelo is the MD of Mashitisho Attorneys Incorporated.